Good evening, good morning, or good afternoon, wherever you may be. And I'd like to welcome everybody here to this seminar in the Peking University School of Transnational Law, Law and Humanities seminar series. My name is Norman Ho. I teach here at the law school. And we're very privileged and honored today to have as our guest speaker, Professor Mohammad Fadel, who serves as Professor of Law at the University of Toronto Faculty of Law. His research and teaching interests include Islamic law, Islamic legal history. He also writes in the areas of international law, law and globalization, as well as business corporations and family law. And he holds a JD from the University of Virginia School of Law and a PhD from the University of Chicago, where he focused his studies on medieval Islamic legal history. Besides his academic experience, Professor Fadel has also served as a judicial law clerk at the United States Court of Appeals for the Fourth Circuit, and also practiced for a number of years at Sullivan and Cromwell in New York. And today he's going to speak to us on the topic please excuse me if I don't get the pronunciation entirely correct, doctrinal change in Mālikī law, the case of judicial divorce on account of harm, ḍarar. And Professor Fadel will speak for approximately 40 minutes, and after which we'll open the floor for questions and discussion up to about 30 minutes. Professor Fadel, thank you very much for being with us. Welcome, and over to you.
Thank you very much. I'm just going to set my watch here. Oh, well, I'll just keep, anyway, we'll keep track. Thank you very much for this invitation. Let me speak a little bit about the place of this project in my work. Francis began to ask me about it. So this presentation is based on a paper that is forthcoming in the Journal of Comparative Legal History that should be out in January of next year, if all things go well. But the paper itself is part of a much larger book project. The book project is out now under review. I hope that it gets accepted, but as I was explaining to Norman, it's monstrously long. It's a 200,000 word manuscript, so I don't know how they're going to react to it. But the manuscript is basically what I would call a jurisprudential history of the Mālikī school. And it's organized around themes of HLA Hart about sort of what makes a legal system. And so the book basically tries to apply Hartian concepts of the rules of recognition, the rules of adjudication, and the rules of change to the history of the Mālikī school of law. And that's sort of how the book is organized. It has two chapters about rules of change, one of which is I call retail rules of change, where I discuss I have several case studies of what I would characterize as significant but marginal marginal changes internal to pre-existing legal doctrines. The second chapter deals with the problem of what I call wholesale legal change, when an entirely new legal doctrine arises that did not exist before in the school. And so judicial divorce, I argue, is precisely such a doctrine. So that's sort of where it comes about. Now let me start. I need to share my screen here. Let me see if I can do that. I'm always running into problems with Zoom. Okay, does everybody see that? We're good? Okay, great. Okay, so judicial divorce upon proof of harm is a distinctive doctrine of the Mālikī school of law. The other Sunni schools of law do not recognize this as a right. Instead, if a husband is abusing his wife, the typical remedy is in the criminal law. The judge can punish the husband, put him in jail, do other sorts of things, but it is not a ground for divorce. So the Mālikī school in the history of Islamic law is unique in affording a woman a right to judicial divorce upon proof of harm. And this is set out the rule is set out in a 14th century work known as Mukhtasar Khalīl, which elsewhere I've argued sort of represents a kind of codification of Maliki law. Khalīl was an Egyptian. He wrote in the, say, mid-14th century. And he says in the relevant chapter of marriage, she has the right to a divorce upon proof of abuse, ḍarar, even if the proof did not establish that the abuse occurred repeatedly. So this becomes black letter doctrine, representing the Maliki position. Now, what's interesting, again, is that this becomes ubiquitous in the modern period. So modern Muslim states, post-colonial states, I can't say if every single one of them, but the vast majority of post-colonial Muslim states have adopted this Maliki rule as part of family law reforms in the modern era. So it's a kind of historically significant rule. Now, there are secondary doctrines associated with this notion of judicial divorce that relate to other rights of the marriage contract. The first is dissolution of marriage. So one method of dissolution of marriage in Islamic law is a consensual divorce, whereby the husband and wife agree to divorce upon financial terms. Typically, this would be that the wife returns some or all of her dower to the husband in exchange for a divorce, right? But the Malikis have, again, a unique position on this, is that if the wife was coerced into a settlement, coerced into financial settlement, she would have the right to rescind the financial terms of the divorce agreement and recover her property, okay? So Khalīl, again, codifies this position and says that she can prove abuse with hearsay, okay? And he also adds that even if she waives her right to allege abuse post-divorce in the divorce settlement, she is still allowed to present evidence of abuse, right? So even a contractual waiver of her right to sue for or claim abuse is not enforceable, okay? And then Khalīl reaffirms the admission of hearsay in the chapter on evidence, where he says widespread hearsay accepted as true by upright witnesses and others is admissible upon the testimony of two witnesses and the claimant's oath to prove spousal abuse. Okay, so these are three distinct positions of the Maliki school. First, that a wife can obtain a judicial divorce by proof of harm. Second, that proof of harm vitiates her consent to the monetary terms of a consensual divorce. And third, a wife can prove abuse in the context of a marital relationship through widespread and notorious hearsay. Okay? Now, this doctrine of harm, of spousal harm, in fact, I say becomes imperialistic, so to speak, in the sense that it begins to displace even other black letter doctrines within the Maliki school. So, for example, there's this oath of abstinence, which was a practice in pre-Islamic Arabia, where a man would swear an oath to refrain from sexual relations with his wife. So the Quran condemns this and said that if he does such an oath, he has 4 months to retract it, at the end of which he must divorce her. Right? There's dispute whether he divorces her or the judge. Anyway, I don't want to get into all that. But there's a 4-month waiting period for this oath before it takes effect, right? But with the rise of this theory of harm-based termination of marriage, later Malikis allow a wife who is subject to such an oath, right, which is actually comes to be interpreted quite broadly, that she can ask for an immediate divorce. She doesn't have to wait for 4 months because the conduct of the husband itself is interpreted as causing her immediate harm, justifying judicial intervention, right? Likewise, the same doctrine applied to cases of missing husbands, where a wife could bypass the waiting period and get divorced immediately based on theories of harm. So the question that the chapter or the article poses is, how did these doctrines arise? right? Because they aren't really present in the early foundational period of the Mālikī text, the Mālikī school. And if some of you have had any experience or studied any Islamic law through the secondary literature, you're likely to have encountered the view that because Islamic law is a religious law, it's not amenable to change, right? That the rules are immutable. Francis told me that he studied with Anderson. Anderson has an article titled something like, "Is the Sharia doomed to immutability?" Right? So this is an example, a case study, a detailed case study of showing how legal change actually occurred and was considered legitimate. So I've identified what I call 4 different vectors of legal change that ended up creating or being responsible for the creation of this set of doctrines. The first is the powers of judges, right? Particularly the right of Mālikī judges to exercise something akin to police power, right? So this becomes very important, as I will show. Second vector of change is the intersection of property rights and the law of evidence. Here, the decisive development was the admissibility of hearsay, right? The ordinary rules of evidence required witnesses to testify only based on direct knowledge. But as we will see, as we've already seen, an exception is made in the case of abuse for hearsay. The third is tort law, how domestic abuse intersected with general principles of tort law. Here, is the important distinctions are between intentional and non-intentional, and compensable and non-compensable torts. So I've kind of translated compensable or as analogous to something like a felonious battery versus a misdemeanor battery, right? And then finally, the last and perhaps the most decisive vector of change was the role of private ordering in Islamic law. And this comes about in 2 different ways. The first is what I call immoral oaths, where husbands swore to do acts that would constitute crimes against their wives, right? And so that presented opportunities for judicial intervention that eventually helped develop this doctrine of divorce based on harm. The second was what I call the covenant of good treatment, whereby women began inserting in their marriage contracts a right to divorce themselves on the occurrence of abuse. And that this covenant of good treatment became adopted in the notarial practice in the Middle Ages. So that's the standard form of marriage contract that circulated among Mālikīs included this covenant of good treatment along with a private right for the wife to divorce herself upon breach. That's what's known as tamlik. So let's begin with the powers of the judge. Now, these derive from an explicit verse in the Quran that speaks about marital breakdown, in which the Quran contemplates an arbitration process, where one arbitrator is appointed from the family of the husband and one arbitrator from the family of the wife, and they sort of investigate what's going on, try to reconcile the parties, and come to some sort of resolution. According to most schools of Islamic law, the arbitrators have no judicial power over the dispute. All they can do is make recommendations. This is an idiosyncratic position of the Mālikī school, that the arbitrators essentially have plenary power over the dispute. They can decide whether to keep the marriage intact or to divorce the couple, and if they divorce the couple, on what financial terms, right? So this is, the foundation of what I would call the extensive powers that Mālikī doctrine afforded judges in supervising marital disputes. And so this is developed further in the 3rd Islamic century or the 9th Common Era by this figure known as Qadi Ismail, who was in Baghdad, the very powerful judicial figure in the Abbasid Empire. And he writes that judges have a duty to intervene in conflicts in the context of marital disputes, and he must he must prevent abuse that takes place within the household and give each of the husband and the wife some sort of remedy, right? Essentially later, another Maliki judge in Baghdad says that it's an obligation of the judge to separate quarreling couples by divorce in circumstances where reconciliation is impossible, regardless of their consent, because of the injury that arises to themselves and by implication to the public interest. This doctrine, in fact, is even developed further in the next century by a North African Maliki judge and jurist named Abu Hassan al-Lakhmi. He served in Qayrawan, which is in present-day Tunisia. And he said a judge does not even need to wait for a complaint before he can intervene in cases of domestic conflict and abuse. As soon as word of the dispute reaches him, he can intervene and take jurisdiction over the matter and resolve it, even if the parties themselves don't file a complaint. Finally, if we go to Andalusia, the Maliki judge known as Ibn Rushd, the grandfather. He's called the grandfather because his grandson was also a judge. His grandson was Ibn Rushd, who's well known in the West as Averroes, just out of curiosity. In any case, Ibn Rushd, the grandfather, was a very important Maliki judge and jurist. He was the chief judge in Cordoba. And he explains why arbitrators have this plenary power over the parties, and that they are engaged in essentially an inquisitorial process. Ordinarily, civil litigation in Islamic law is an adversarial process. The judge is not responsible for obtaining evidence or questioning the parties. The parties are responsible for bringing evidence to the court. Because of that, in ordinary civil litigation, parties have a right to impeach the evidence of their opponents, but no such right exists in marital disputes when the arbitrators intervene, because as he explains, arbitrators are acting as inquisitors, right? They're gathering evidence for themselves and making judgment for themselves. So there's no room for cross-examination and impeachment as it applies in normal civil litigation. Okay. Moving on then to property rights and evidence. Again, here in the earliest period, we see the rule that if the husband coerces a settlement, it is invalid. The monetary terms are invalid, and he must return the property to her. But the divorce continues in effect. But as you see, there's no rule of evidence to give effect to this rule, right? And so this only comes about if, well, this becomes the problem. How does a woman prove that she was abused in this circumstance? So Ibn al-Qasim, who was the chief student of Malik, explains in another early Maliki text that hearsay is admissible, right? So he says, for example, who else could testify? Right, so let me get the right slide here, sorry. So he's asked whether or not hearsay testimony is admissible to prove abuse in this case, and he says, yes, and who could testify about this except by hearsay? A man hears about this from his wife and household, from the neighbors and similar sources, and it becomes something notorious. So a hearsay exception is recognized here for two reasons. First is because it's impractical to expect witnesses to have direct knowledges of abuse, because abuse happens in the privacy of homes. And so if you don't allow hearsay, you'll never have a means of proving it. And second, and this is important, it's a matter of property, because what's at issue here is not the divorce. The divorce has been established by the evidence of the agreement of the spouses to separate. The only thing that's in dispute is whether or not the wife can has a right of restitution to the property delivered to the husband. And so that's a property dispute. And in Islamic evidentiary law, lesser standards of evidence apply to property disputes than they do to divorce proceedings. Okay. The law of abuse intersected with the law of torts because there was a special rule of tort law that applied to domestic violence, because Islamic law afforded husbands a prerogative to discipline their wives using physical means, right? Using corporal punishment. So that was a prerogative of the husband. At the same time, background principles of tort law continue to apply, but in a modified way. And this is reflected in the early text in the Muwatta, where Mālik says that if a husband intentionally seeks to abuse his wife in some sort of way by, gouging her eye or amputating a limb or something like that, then the ordinary rules of intentional tort apply and she can retaliate against him. But if he strikes her without the desire to inflict a grievous bodily injury on her, but that is the result, then she's only entitled to financial compensation, but not a right to retaliation. And so what's important here is not simply the desire to incorporate the husband's right of physical discipline within background principles of tort. I wanted to point out these rules because they don't provide the wife a right of divorce. So in the earliest period of Islamic law, in the second century, second Islamic century, 8th century of the Common Era, a husband could be guilty of an intentional tort against his wife, and she could have a right of retaliation against him, but that did not give rise to a right of divorce. But that came about gradually subsequent to this idea. And this is where the idea of the immoral oath becomes very important. So Mālik is asked about a man who swears to administer a severe lashing to his wife upon pain of divorce, i.e. if he doesn't do it. So Mālik says that if the judge were to become informed of such an oath, he should prohibit the man from fulfilling his oath and divorce the wife immediately, right? Now note here that the divorce is taking place as a consequence of the husband's failure to carry out the terms of the oath. He swore, she is divorced unless I lash her like 50 times. He is prevented from carrying that out because it would be a crime to do so. But because he fails to carry out his oath, the consequence of the oath arises, right? By operation of the oath, not by judicial decision. Right? So still here, the divorce arises because of the private action, not because of the judge, right? In another case from Andalusia, where a husband abuses his wife, right? He swears an immoral oath, then carries it out, right? Ibn Habib, another important 3rd century Maliki author, contemplates judicial divorce if the injuries are manifest and severe. But his theory about this is that she loses social standing among women in her class, right? That his treatment of her is not consistent with her status as a free woman, so that entails a right of divorce. Okay. The other dimension of private ordering is the positive one of the covenant of good treatment. Again, the evidence that this covenant enters into practice is no later than the 3rd Islamic century, 9th century, the Common Era. So a jurist is asked about a woman who inserts in her contract a right to divorce herself if her husband treats her poorly. And then she asks, well, if he beats me, does that constitute poor treatment? So the jurist replies that if she has done something that was a breach of the marriage contract that warrants discipline, then it's not ill treatment. But otherwise, if she did nothing to deserve punishment, or if he just habitually strikes her, even if the striking is not severe, then that constitutes poor treatment and she can act on her contractual right of divorce. Right? So by the end of the 4th century, we find this covenant of good treatment mentioned in standard form contracts, but it's merely a promise. So in this text, al-Wathā'iq al-Majmū'a, which appears in the 4th Islamic century, 9th, 10th century Common Era, he has numerous provisions which allow the wife to divorce herself. For example, if he removes her from her hometown against her will, she is free to do as she wishes, meaning that she can just divorce herself if he seeks to move her from her hometown to another town. And then he says he's obliged to be a good companion to her and use his best efforts to live with her harmoniously, as God, may he be sanctified and glorified, has commanded him. But that is not accompanied by a right of divorce upon breach. So that's just merely a contractual promise. But a couple of centuries later, in the 8th century and the 14th century, the standard language has changed. It now incorporates the right of divorce. So in the form contracts of the 8th century, it says, and not to injure her, either in her person or her property. And if he does cause her injury in either of these, he has given her power over her own affair, meaning she can decide to divorce herself. This is then reflected in the judicial manual from the 7th century. Another judge from Cordoba, and he kind of attributes this principle to Mālik more broadly and says that if a man abuses his wife, she can prove by hearsay the abuse and get divorced. Now, I've argued in the paper that this is a complete misattribution. This is something that was made up at some point in time, because this attribution of this rule to Mālik is completely implausible. There's nothing in the earliest sources of Maliki law that would affirm the idea that Mālik said anything like this. But this rule that is attributed to him actually reflects the rule that Khalīl sets out in his restatement in the 14th century. So to conclude, judicial divorce for harm is a distinctively Maliki doctrine. It does not become firmly established until the 8th or 14th century with Khalīl's Mukhtasar. It's a synthetic position that arises out of numerous strands of independent doctrinal development, not present in early Maliki sources. These doctrinal strands include doctrines intended to protect wives' property, the judicial duty to protect wives from credible threats of manifest torturous abuse, contractual provisions in marriage contracts, the binding nature of marital arbitration, and the merger of legal and police powers in judicial administration. So thank you for your attention. I look forward to your questions.